This is an incredibly serious crime. It is well orchestrated. It demonstrates conniving and planning. She's a well-funded defendant with evidence of her being able to go to extreme lengths to get what she wants. And if that wasn't enough, she was arrested at the airport with a one-way ticket to a non-extraditable country. That is what we call a no-brainer. Utah mom and so-called grief author Kouri Richins makes several last desperate attempts to have damaging evidence tossed before her approaching trial for murder. Plus, another Utah woman is denied bail after the court hears detailed and shocking evidence connecting her to the slaying and disposal of her husband's body, which has never been recovered. And Florida matriarch Donna Adelson receives 2 devastating setbacks before she stands trial for orchestrating the execution of her son-in-law, Dan Markel. All this and more this week on Courtroom Confidential. The world of true crime news seems to always be packed with twists and turns, and this week is no exception. We are recording this episode on Friday, March 7th, 2025, and this is your Courtroom Confidential Weekly Roundup. Kouri Richins, the Utah mom charged with aggravated murder for allegedly poisoning her husband, Eric Richins, with fentanyl in 2022, appeared in court this week for a hearing on what evidence will and won't be allowed at her quickly approaching trial. The hearing centered on a phone seized by Summit County Sheriff's detectives and the contentious, quote, walk the dog letter found in Richins' jail cell. Defense attorney Kathy Nestor argued that law enforcement had no legal authority to take Richins' phone, and it was not in her possession when seized. Quote, what they did was search a vehicle using her hands to do it, directing her to hand something out of the vehicle that they did not have authority to grab, and they grabbed it, and that's our position, Nestor told the court. She went on to argue that Richins was coerced by officers into providing her phone's passcode. Quote, it was, give me your passcode, from an armed police officer while surrounded by armed police officers in a house where she had just been detained for 20 minutes. Chief Prosecutor Brad Bloodworth countered that there was a break in the sequence of events and that the defense had not met the burden required to suppress the evidence. Debate also arose around the walk the dog letter, which Richins wrote to her mother. The defense claims the letter fell under certain legal protections, while the prosecution described it as an attempt to witness tamper, influence the public, and retaliate against the Richins family. At issue was whether the letter qualified as attorney-client communication or attorney work product. Defense attorney Wendy Lewis contended that Sergeant Thomas improperly read and disclosed the letter. Quote, something went off the rails here, and instead the document was read improperly by Sergeant Thomas based on that first paragraph, and then it was immediately disclosed publicly as part of a pleading. Bloodworth countered that Richins could have testified on the matter but chose not to, which would have subjected her to cross-examination. Judge Richard Mrazek then pressed Bloodworth on the letter's intent, asking, quote, when the defendant writes in a letter that appears to be about to go to her mother but never did, Sky says X, Y, and Z, why would I suggest? Why do I have any basis to think that she's not going to be truthful with her mother about what Sky said? Bloodworth responded, quote, because of all of the untruthfulness throughout her entire history of being detained, prompting an objection from the defense and a scolding from Judge Mrazek. Quote, let's pause for a second. She's presumed innocent of all of that, so I got to stay in the face of the document. Judge Mrazek stated he would take the motions under advisement and issue written rulings. He also addressed the potential for a motion to move the trial out of Summit County, instructing the defense to file any such motion by March 14th. The state will have 14 days to respond, and the court will hear arguments on April 7th. Well, what's happening here? Let's first talk about the phone. What is so interesting about this case and the arguments that are now being made, these in limine evidentiary arguments, is that it really demonstrates just how fluid and shifting an interaction with the police can be for a suspect, for a defendant. Not everything can fall so neatly into these cleanly defined levels of probable cause. In one situation, a person may be in custody, and that's apparent to everyone, and no one disagrees with it. And then a moment later, for whatever reason, some change in circumstances, and that answer is not so clear. Here, the question in large part was, did the police have probable cause to seize items on Kouri Richins' person? And does that extend to her phone that was in the center console of her vehicle at the time that she was having this conversation with police? And was telling Richins to hand over her phone an order, or was it something that she could have refused? Did police have a reason to seize that phone from inside the vehicle themselves in order to avoid any possible evidence tampering? These are all very good questions, all difficult questions, and I would submit all questions that don't have the easiest and most clear-cut answers. You can see how quickly these issues begin to pile up, and the outcome is not as clear as it may seem at first glance. But what about the infamous walk the dog letter? This letter clearly begins, in my view, with a discussion about Richins and her lawyer. The first sentence is, quote, Sky, that's her lawyer, is saying even if the gummies, and there's evidence that Eric may have used pot gummies, have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric, her husband, would have them. What do we have in that first sentence? We have the defendant talking about the thoughts of her lawyer, expressing those thoughts, expressing how certain pieces of evidence might be viewed by the prosecution and how they need to respond to that, or a concern that they have with that, or how they know that at trial that will need to be something that they need to address. Now, as far as this argument goes that this was attorney-client privileged information, in order to qualify for that, it has to be, first of all, a communication between the client and their attorney. This was a letter that was obviously intended for her mother, and it has to be confidential. In other words, by giving it or even reading it to her mother, the mother pierces all of that confidentiality. Is this attorney-client privileged information? I think not so much. But the work product issue is very interesting. Work product are documents prepared by an attorney, by sometimes the client, in anticipation of litigation, anticipation of trial. In other words, not just every single thing that a lawyer writes down, not every note taken is necessarily in anticipation of litigation. It also protects the mental impressions, conclusions, and legal theories of that lawyer or client. Remember again what we talked about in that first sentence. She's talking about how this evidence might be viewed, what they need to do with that, their legal theories behind it, their conclusions, their impressions. I think it squarely falls into that overall concept of attorney work product. Perhaps. Do you get to hide clearly contraband material in a document that you just start out with indications of work product? I think the prosecution would absolutely say yes. She may have, in that first paragraph, coached this in such a way that there's an argument to be made that it's work product. But then the rest of the letter goes on to talk about how to coach witnesses, which is improper. Again, gray issues, issues on top of issues, and all really tough calls for the judge. So what do you guys think? Do you think that this letter should be admitted as evidence? Please let us know in the comments. At a recent detention hearing, prosecutors revealed new evidence against Jennifer Gledhill, accused of murdering her estranged husband, Matthew Johnson, a Utah National Guardsman who has been missing since September 2024. Gledhill's request for bail was denied after prosecutors argued she posed a threat to the community, including a confidential informant. Salt Lake County Prosecutor Emily Paulos began her remarks with a direct statement to the court. Matthew Johnson is not missing. Matthew Johnson was murdered by the defendant. Prosecutors presented images from the couple's Cottonwood Heights home showing blood-stained carpet and bed slats in the master bedroom. DNA analysis confirmed the blood on the carpet belonged to Johnson. They believe Gledhill shot Johnson while he was in bed, citing a video of the couple arguing and testimony from an informant who claims Gledhill confessed. Quote, on September 22nd, the defendant confessed to the informant that she shot Matthew in the master bedroom with a gun as he slept. She also confessed that she loaded Matthew's body into a rooftop storage container, slid him down the stairs, and loaded him into their minivan. She buried him in a shallow grave and cleaned everything up. Prosecutors say forensic evidence corroborates much of the informant's account. A map shown in court tracked Gledhill's phone activity on the morning of September 22nd, tracing her movements from Cottonwood Heights to Kaysville. A rooftop storage container, later found in a Davis County wetland after a storm, contained traces of Johnson's blood. Prosecutors believe it floated from where Gledhill hid it. The court also saw images of evidence that Gledhill allegedly discarded, including the master bed's foam mattress, pillows, and a rug. Palos returned to discussions of the informant where Gledhill allegedly referred to Johnson in the past tense. Quote, he wasn't a person anymore. He wasn't Matt anymore. This was when Gledhill added a final ominous epilogue. Quote, I always preach that I was like the Queen of Hearts in my past lives because I'm like off with their heads. Gledhill will return to court on Friday, March 14th for a pretrial conference. What's happening here? Do yourselves a favor and watch this bail hearing. In fact, better yet, we have a video where we broke down the hearing. That will be included in the description of this video, but go and watch it. It played out like a miniature opening statement plus much of the evidence in the case. It was remarkable to watch. I'm rarely so impressed by a hearing like this. And this was just a bail hearing, just an opportunity for the judge to understand the smallest amount of evidence that they have so that the judge knew why she should be denied bail. And it included physical evidence. They have blood. They have traces of blood throughout where they believe he was shot, throughout where they believed he was stored, and where they believe he was transported. They have DNA indicating that is in fact his blood. They have cleaning materials. They tracked down other evidence, the discarded mattress, the rugs, the rooftop storage unit, and they found the receipts. They have pictures, many recovered from the defendant's own phone, that show these items, the mattress, the rug, the storage unit, before at their house, being able to connect those final dots. They have GPS tracking, and if that wasn't enough, they have the coup de grace, the confidential informant who puts it all together. So what does the defense do in a case like this? Well, my answer is I don't know. But I'll tell you this. One question I have is, how did she do this? She's described it, but how physically was she able to accomplish this? Her husband was not a small man. She had to shoot him, pull him off of the bed, drag his dead weight body, load him into that storage container, down the stairs, load him into the minivan, then get him out again, bury his body. I'm not saying it's impossible, but it does suggest an incredible physical exertion. And the other thing it might suggest is that she had help, was another person involved. Now, I can hear already what you're all saying. That doesn't mean that she's not guilty. Of course not, but it does raise questions. And at this point, with everything that I've heard, maybe that's all the defense has left, is just questions. Now, one last thing on this case. We do know that her parents were arrested. They were arrested back in October, Thomas Gledhill and Rosalie Gledhill. And they were arrested for 4 felony counts of first-degree obstruction of justice. Police believe that they were involved in the cleanup. Now, could this be the answer to that question? Could they have also helped in the disposal of the body? Perhaps a 71-year-old man and a 67-year-old woman? I don't know. But in my view, the physicality involved in hauling that body down suggests that she had help. And I think if police felt that mom and dad was involved in that, they would have been charged differently than just obstruction. It would have been accessory after the fact. You don't get to help dispose of a body and just call it obstruction. In either case, the defense is really in a spot here where I think more than anything, they just want to bring up questions, and hopefully some of those questions will cause confusion, and hopefully some of that confusion, if you're the defense, might cause reasonable doubt. But I doubt that. But what do you guys think? Do you think Jennifer Gledhill had help in the killing, in the disposal of that body? Please let us know in the comments. Judge Stephen Everett ruled this week that Donna Adelson must remain in jail until her trial, currently set for this summer. In a 3-page ruling unsealed Tuesday, Judge Everett denied Adelson's request for bond, rejecting her attorney's claims that she felt unsafe in jail due to alleged assaults, threats, and extortion. Adelson, age 76, is accused of orchestrating the 2014 murder for hire of her former son-in-law, Dan Markell, at his home in Tallahassee. In another decision with likely more significant impact on the trial, Judge Everett also denied a defense request to suppress a recorded jail phone call between Adelson and her son Charlie soon after his conviction. Court records showed that in November of 2023, Donna received a call from Charlie, who was in Leon County Jail. Charlie was disconnected after about 8 minutes, and for the next 15 minutes, she spoke with her husband, an estate planning attorney, and the attorney's husband. During this time, she alluded to taking her own life, discussed fleeing to countries without extradition agreements with the U.S., and mentioned a conversation with her daughter, Wendy Adelson. Adelson's attorney argued it was a, quote, unlawful warrantless interception to record the call after Charlie was disconnected, and she believed the call had ended. However, Judge Everett reasoned that Adelson was well aware that she had no reasonable expectation of privacy when she answered the phone and consented to speak with her son on a recorded jail line. Further, Judge Everett highlighted how Adelson was aware of how the phone calls had worked in the past and would only be ended once both parties had disconnected from the call. Adelson's next court date is set for March 25th. What's happening here? Let's talk about the bail first. I think the only person who is possibly shocked by this decision is Donna Adelson herself. This is an incredibly serious crime. It is well orchestrated. It demonstrates conniving and planning. She's a well-funded defendant with evidence of her being able to go to extreme lengths to get what she wants. And if that wasn't enough, she was arrested at the airport with a one-way ticket to a non-extraditable country. That is what we call a no-brainer. There's no way the judge was going to grant her bond in this case. I think that was simply done so Donna would stop asking about it. The more important thing that took place in court this week, though, the meat and potatoes of this week's motions, was that jail call. It's far more interesting from a legal perspective, and it's far more consequential to the results of the trial. And really what this all comes down to is the question of reasonable expectation of privacy, and how that expectation of privacy can be affected if the defendant fails to take simple precautions. Many times we assess an expectation of privacy given the environment. How can the environment determine whether or not a person has a reasonable expectation of privacy? Here's what I mean by that. If you're out in public, if you're at a crowded restaurant, if you're at the office with people around you and you're having a conversation, you can't really say at that point that you have a reasonable expectation of privacy in that conversation. But if that same conversation takes place inside your home, with the doors and windows closed, you do have a reasonable expectation of privacy. Now, how can that be affected, however, by the defendant's actions or failure to act? That same conversation taking place in the privacy of your own home, if you're yelling at the top of your lungs and you know you have thin walls to your neighbors, maybe not so much. Here, she's having a private conversation with her husband and her attorney inside of her home. I don't think anyone questions that under normal circumstances, that would have a reasonable expectation of privacy. But now enter into this fact pattern that she's on a recorded jail call. Already she's on notice that this wasn't a normal phone call. This is a phone call where it's going to be recorded by the very people who are likely investigating her. Take it one step further and show that she didn't hang up. Add to that she had experience with these calls dropping before and knew how to end the call. Judge Everett puts it best. He says, quote, "The defendant testified that her son was frequently disconnected during phone calls from the Leon County Jail. During these other instances, the defendant answered she would ordinarily hang up the phone after he was disconnected," suggesting she realized she needed to hang up her phone to end or terminate the calls. It becomes abundantly clear Donna should have known better. But what do you guys think? Do you think this conversation should have been considered private and therefore suppressed and kept from being viewed by the jury? Please let us know in the comments. Hey, everybody. Before we head into the other cases making headlines this week, I'm going to ask one very small favor from you, and that is, if you haven't already, please take a moment to subscribe to our channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way that we can do that is through your support. And don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, Karen Read's defense attorneys clashed with prosecutors in a heated two-day hearing ahead of her April retrial for murder. The Mansfield, Massachusetts woman is accused of striking her police officer boyfriend, John O'Keefe, with her SUV outside a Canton home on January 29, 2022, and leaving him to die in a snowstorm after a heavy night of drinking. Her defense has long maintained that Read was the victim of a cover-up and that law enforcement officers were responsible for concealing O'Keefe's murder. Read and her legal team have faced increased scrutiny in recent weeks after Special Prosecutor Hank Brennan accused them of misleading the court regarding inappropriate contact and payments to defense experts. At the start of Tuesday's proceedings, Judge Beverly Cannoni reminded Read's attorneys that each member of the defense team is responsible for any misstatements made in court. Another bomb was dropped when Prosecutor Brennan revealed that a federal investigation into the case had been closed, though no details on its findings were revealed. Brennan then proposed sealing all future motions and placing attorneys under a gag order. On Wednesday, Read's defense team appeared in federal court, arguing that two of the charges against her should be dismissed on the grounds of double jeopardy. During the 90-minute hearing, Chief Judge Dennis Saylor listened to arguments about whether Judge Cannoni had properly declared a mistrial and whether she should have polled the jury before doing so. Read's attorneys argued that post-trial contact with jurors indicated they had reached a unanimous verdict acquitting her of second-degree murder and of leaving the scene of an accident resulting in death. Judge Saylor said he would issue his ruling as soon as possible, acknowledging that whichever side loses is likely to appeal. Read's retrial remains scheduled to begin on April 1st. Later that same day, Read and her attorneys were back in court in front of Judge Cannoni to argue their motion to dismiss based on extraordinary governmental misconduct, allegations of jury tampering, and questions over footage of Read's vehicle in the Canton Police Department Sallyport taking center stage. The jury tampering claim revolves around a juror who was dismissed just before defense attorney Alan Jackson delivered his closing arguments in Read's first trial. Jackson pointed to Lieutenant Fanning, the person who raised concerns about the juror, as someone involved in the investigation and implicated in some of Trooper Proctor's inappropriate text messages. Proctor was also connected to the missing Sallyport footage, which was turned over to the defense in pieces, beginning with an inverted video shown during Read's first trial. Proctor had custody of the footage since 2022, but did not provide it to the prosecution or defense until 2024, an omission that Prosecutor Brennan has described as an oversight. Judge Cannoni has not issued rulings on any of the issues raised. We will be back in court on March 18th and 19th for further pretrial hearings. On the night 4 Idaho college students were stabbed to death in an off-campus home, their 2 surviving roommates were frantically trying to reach them, according to text messages included in court documents made available on Thursday. The filings in the case against suspect Bryan Kohberger provide new details about the timeline of events on November 13, 2022, inside the residence near the University of Idaho in Moscow, Idaho. Prosecutors say the 4 victims, Kaylee Gonzalez, Zaina Kernodle, Ethan Chapin, and Madison Mogan, arrived home around 1:45 a.m. One of the surviving roommates messaged an Uber driver to take them home from a bar to the house at 2:10 a.m. At that time, the other surviving roommate was also awake and texting. At 4 a.m., Kernodle received a DoorDash order. One surviving roommate later told investigators she believed she heard Gonzalez playing with her dog. Shortly after, the roommate recalled hearing someone, who she thought was Gonzalez, saying something like, quote, "There's someone here." At 4:17 a.m., a security camera less than 50 feet from Kernodle's room captured the sound of a barking dog, followed by, quote, "a distorted audio of what sounded like voices or a whimper, followed by a loud thud," according to prosecutors. By 4:22 a.m., both surviving roommates were texting back and forth, appearing increasingly alarmed as their calls and messages to the 4 victims went unanswered. Quote, "No one is answering," the roommates, identified only by their initials as DM, texted BF between 4:22 a.m. and 4:24 a.m. "I'm really confused right now." Later, DM referenced seeing someone in, quote, "like a ski mask almost," with BF responding, "Shut the F up." Quote, "I'm not kidding," DM replied, adding they were so freaked out. Quote, "Come to my room," BF said, "Run." One roommate told investigators, quote, "She looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. She opened her door a second time when she heard what she thought was crying coming from Kernodle's room. She then said she heard a male voice say something to the effect of, "It's okay, I'm going to help you," according to previously filed documents. The roommate said she opened her door again and saw a man in black clothes and a mask walking past her, according to an affidavit. She stood frozen and in shock as he walked towards the house sliding glass door. The roommates described the man as at least 5'10" and not very muscular, but athletically built with bushy eyebrows. Both surviving roommates are expected to testify at the trial. The newly released filings also include a redacted transcript of the 911 call placed at 11:58 a.m., nearly 7 hours after the intruder was seen. After the discovery of Kernodle's body, quote, one of the roommates who's passed out and she was drunk last night and she's not waking up," adding later, "Oh, and they saw some man in the house last night." Kohberger was arrested in December of 2022 following a 6-week manhunt. He was indicted in May of 2023 on 4 counts of first-degree murder and 1 count of burglary. If convicted, he faces the possibility of the death penalty in Idaho. His trial is scheduled to begin in August. The son of a man accused of killing his wife and hiding her body now faces felony charges for allegedly assisting in the crime. Jaron Dale Warner was arraigned Monday, March 3rd on charges of tampering with evidence and being an accessory after the fact in connection with the disappearance and murder of his stepmother, Dee Warner, according to Michigan State Police. Dee Warner was last seen leaving her home on the morning of April 25th, 2021. Authorities launched a search of the property on October 12th, 2021, but found nothing. After more than 2 years missing, she was presumed dead. Dee's family held a press conference in May of 2022 where investigator Billy Little presented evidence alleging Dale Warner was responsible for her death. Dale was later arrested and charged for her disappearance and murder in November of 2023. In August of last year, police discovered Dee Warner's remains on Dale's property inside a welded shut storage tank. Dale has denied harming his wife, telling authorities he was out farming the morning Dee disappeared. Dale is awaiting trial, which is set for September 2nd. Meanwhile, his son Jaron's bond was set at $125,000, and he is scheduled for a probable cause conference on March 10th, with a preliminary examination hearing scheduled for March 17th. More than 8 years after famed hairstylist Fabio Cementelli was stabbed to death on his Woodland Hills patio, one of his killers testified that the stylist's widow wanted him dead. Christopher Austin, who was convicted of second-degree murder in the case, told jurors he and Robert Baker carried out the killing after Monica Cementelli left the door to the couple's home unlocked. Testifying this week as the prosecution's star witness in Monica's murder trial, Austin said he never communicated directly with Monica, but Baker, her lover, told him she wanted Fabio gone. Quote, everything he did after he got a text message, which told me he was talking to her via text message, Austin testified. Quote, I did not hear him talking to her on the phone, but everything happened in sequence. Austin testified that Baker referred to Monica as his girl and claimed she was in an abusive relationship, but after the stabbing, Baker admitted the killing was for insurance money. Prosecutors say Monica masterminded the plot to collect $1.6 million in life insurance and avoid a divorce. Baker, a convicted sex offender and former porn star, met her while coaching racquetball at LA Fitness in West Hills. Baker and Monica have admitted to their affair, but Baker, who pled guilty to first-degree murder and received life without parole, has insisted she wasn't involved. For the first time in court, Austin gave a step-by-step account of the murder. He testified that he and Baker approached the home and found Fabio sitting on the patio. Fabio never saw them coming as Baker opened the door to the patio. Quote, he opened the door and he held his mouth so he couldn't scream, Austin testified through tears, and he started stabbing him. The men then fled to Fabio's Porsche, which Baker knew was in the garage, making it appear as a home invasion gone wrong. During cross-examination, defense attorney Leonard Levine highlighted repeatedly that Austin had never heard directly from Monica Simontelli about the murder plot. Levine also asked repeatedly if Austin had been offered a deal by the prosecution, to which Austin answered no. Austin faces 16 years in prison at sentencing next month for second-degree murder and personal use of a knife. The trial of Robert Crimo III, accused of opening fire at a 4th of July parade in Highland Park, ended abruptly Monday when he unexpectedly pled guilty. Crimo, who faced 69 counts of murder and attempted murder for the July 4th, 2022 mass shooting, entered his plea just before opening statements were set to begin. He pled guilty to 21 counts of first-degree murder, 3 counts for each of the 7 people killed, along with dozens of attempted murder charges. Lake County Circuit Court Judge Victoria Rossetti confirmed that Crimo understood his decision. Quote, is that what you went over with your attorneys? She inquired. Yes, Crimo replied. Crimo now faces life in prison when he is sentenced on April 23rd. Illinois abolished the death penalty in 2011. Dressed in a black suit with the number 47 tattooed on his face and additional tattoos covering his neck and hands, Crimo made no further statements before leaving the courtroom. Lake County State's Attorney Eric Reinhardt emphasized in a written statement that, quote, this was not a negotiation, this was not a deal. He made a free decision to plead guilty to every single count that this trial team and this law enforcement team was about to present to this jury. He received nothing in exchange for the plea today. We are 1,000% ready to go to trial and present evidence today. Reinhardt later told reporters that prosecutors only learned of Crimo's decision that morning. As recently as last week, while jury selection was underway, Crimo had shown no indication that he planned to plead guilty. So-called extreme emotional disturbance will be central to the legal defense of former Kentucky Sheriff Sean Mickey Steins, who is accused of fatally shooting District Judge Kevin Mullins inside the judge's chambers of the Letcher County Courthouse last year. Defense attorney Jeremy Bartley filed a notice last week indicating that expert evidence on Steins' mental state will be presented at trial, potentially arguing that he was not criminally responsible for the shooting. Speaking Monday, Bartley said he believes there may be additional evidence supporting his claim, but declined to provide further details as the case continues. Steins, who has been in custody since the September 19th shooting, has pled not guilty to 1 count of murder of a public official. Mullins had served as district judge since 2009, while Steins previously worked as his bailiff before being elected sheriff in 2018. The motive for the shooting remains unclear. During a hearing last fall, investigators played footage showing Steins shooting Mullins inside his private chambers. Kentucky State Police detective said that Steins attempted to call his daughter just before the shooting, then tried using Mullins' phone to reach her. Last week, Court TV released video footage from earlier on in the day of the shooting showing Steins, Mullins, and 3 others conversing without apparent conflict. Authorities have also noted that the 2 men had lunch together that afternoon. A date for the case's next court hearing has not yet been set. Jurors resumed their seventh day of deliberations Friday in the trial of Jeffrey Ferguson, the Orange County Superior Court judge accused of fatally shooting his wife. On Thursday, the panel signaled once again that they were at an impasse. Los Angeles Superior Court Judge Eleanor Hunter noted there had been some movement but no resolution. Hunter then directed the jury to continue deliberations and discuss whether further guidance from the court would be helpful. The impasse followed additional brief arguments from the prosecution and defense, which Hunter allowed the previous day. Senior Deputy District Attorneys Seton Hunt and Defense Attorney Cameron Talley were each permitted an additional 10 minutes of argument to address juror questions. Soon after the arguments, however, the jury submitted a note requesting clarification on key legal definitions. Quote, "Could we ask counsel for further clarification on what deliberately acted with conscious disregard for human life means?" At approximately 40 hours, the jury has now deliberated longer than the length of the trial itself. They have three options: convict Ferguson of second-degree murder, convict him of involuntary manslaughter, or acquit him altogether. While they are permitted to discuss both degrees of guilt, they must unanimously acquit him of second-degree murder before they can move on to consider involuntary manslaughter. As of the time of this recording, no verdict has been reached. Before we get to what's on the docket for next week, I just want to take a moment to thank you all for your support. The love from our growing community has been absolutely amazing, but I wanted to give a special shout out to Ma of Luna for their fantastic review on Apple Podcasts, as well as to our CC crew members DSN 385 and Lynette Crick 2324 for their thoughtful comments on YouTube. Please keep them coming. We absolutely love hearing from you. And please let us know where you are from. We are thrilled by the growth of our international Courtroom Confidential community. On the docket for next week, OnlyFans model Courtney Clenny, who is charged with stabbing her boyfriend Christian Obumseli to death, will be back in court on Tuesday, March 11th for a status hearing. Texas man Brad Simpson will return to court on Wednesday, March 12th for a discovery hearing. He is charged in the murder of his wife, Suzanne Simpson, whose body has not yet been located. Suspected Gilgo Beach serial killer Rex Heuermann will be back in court on Wednesday, March 12th for further pretrial discussions. David Pierce, who was convicted in the deaths of 2 Los Angeles women and the rape and sexual assaults of 7 different women, will be sentenced on Thursday, March 13th. He faces 148 years to life in state prison. Kentucky woman Toralina Fields will be back in court for a hearing on Monday, March 10th. Fields is facing several charges, including the brutal murder and dismemberment of her own mother. And finally, this Monday, join us for the premiere of the latest episode in our Courtroom Confidential conversation series when we sat down with former FBI profiler and host of the Killer Psyche podcast, Candace DeLong. And that is it for us this week, folks. I am your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. And thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.